Canada Immigration Refusal, Reconsideration versus Judicial Review. Welcome back to Canada Chronicles. If your immigration application, whether it's a study permit, work permit, or permanent residency, has been refused, you're probably asking, what now? In this video, we're breaking down the two main paths available after a refusal: requesting reconsideration or filing for a judicial review. We'll explain what each means, when to use them, and how to avoid the most common and costly mistakes. We'll also share why understanding these two options is more critical than ever in 2025. And stick around, because toward the end, we'll dive into a major trend: a sharp rise in successful judicial reviews. We'll unpack why it's happening and what it means for your chances of turning things around. If you want to stay updated on important immigration news that could impact your future, hit subscribe and turn on notifications. Let's get started. The problem: a surge in immigration refusals. In 2025, more applicants than ever are facing immigration refusals from Immigration, Refugees, and Citizenship Canada. These rejections span study permits, work permits, and permanent residency, and they often leave applicants with limited options. A refusal isn't just a bureaucratic setback. People invest their savings, plans, and dreams into coming to Canada. When those efforts are dismissed, the damage is deeply personal. It can pause careers, break families apart, and leave long-term residents at risk of losing their legal status. Understanding reconsideration requests. A reconsideration request is not a legal appeal. It's a direct and formal request to Immigration, Refugees, and Citizenship Canada to reevaluate their decision due to an error, either in the facts or in applying the law. To request one, you use the official IRCC web form, address your message to the program manager, and provide a detailed explanation. This isn't the time for emotion. It's about pointing out where the officer went wrong based on the documents and facts you already submitted. You're not allowed to add new documents, only highlight existing ones that may have been overlooked. For example, if you were refused for not submitting proof of funds, but you clearly did, then highlighting that document again in a reconsideration request is valid. However, if you forgot a required document or submitted incomplete information, reconsideration won't help. The officer didn't make the mistake. You did. There's also no fixed timeline for a response. Some applicants hear back in weeks, others wait months, and some may not get any reply at all. When reconsideration makes sense. Reconsideration makes sense when IRCC made a factual or legal error. Say you applied for a spousal open work permit and IRCC wrongly concluded that your spouse wasn't eligible, despite being enrolled in a recognized institution. Or your permanent residency application was refused for insufficient funds, even though you submitted valid financial documents and the officer failed to issue a procedural fairness letter. These cases involve mistakes that can and should be challenged. What matters is proving that the officer erred, not just that you disagree with the outcome. Why judicial review is not the same. Judicial review is a legal procedure in federal court. It is not a second look. It's a legal challenge. You are not asking the court for a visa. You are asking a judge to assess whether IRCC made a decision that was unreasonable or unfair according to the law. Judicial reviews are complex. You need a lawyer. The process involves preparing legal arguments, presenting evidence, and submitting sworn statements. But it's often effective. Judges are independent and don't take kindly to poor reasoning or procedural shortcuts by immigration officers. The judicial review process. Here's how it works. If your application was decided inside Canada, you have 15 days to file a notice of application for judicial review. If it was decided outside Canada, you have 60 days. After filing the notice, your lawyer will prepare and file an application record. This includes the refusal letter, all documents submitted in the original application, and a legal argument showing how IRCC failed to follow the law or acted unfairly. The court will then decide whether to grant leave to hear the case. If they do, a judge will hear arguments and either uphold the refusal or send it back for reconsideration by a different officer. This doesn't guarantee approval, but it forces IRCC to reassess the case, often resulting in better outcomes. While preparing for judicial review, every document you initially submitted becomes part of the case record. That's why it's crucial your original application was thorough and well organized. A poorly assembled file or missing explanation in your first submission can make it harder for your lawyer to argue that the refusal was unjustified. Applicants who focus on strong, evidence-backed submissions from the outset stand a far better chance if they later need to challenge a decision in court. Who should consider judicial review? If you did everything right and were still denied, especially without a chance to respond, you should strongly consider judicial review. This is especially true for students who were denied despite providing clear financial documentation, workers refused due to job code errors or misunderstanding their employment, permanent residency applicants whose documentation was ignored or misread. Applicants from countries with high refusal rates particularly benefit from judicial review, as it forces transparency where the regular system can feel arbitrary. Avoiding common mistakes. Too many people file reconsideration requests out of panic. They don't assess whether there's actually an error. Some send multiple web forms, thinking it will increase their chances. It doesn't. Others reapply immediately after a refusal, which can lead to a second denial based on the previous one. This hurts your credibility and makes future applications harder to approve. Still others start both processes, reconsideration and judicial review, without understanding how one could delay or compromise the other. Timing matters. If you wait too long for IRCC to respond, you could miss your court deadline. Additionally, many applicants misunderstand the intent behind these options and submit reconsideration requests, hoping for leniency or compassion. But IRCC officers are bound by policy, not sentiment. Emotional appeals without a legal or factual error are unlikely to succeed, and wasting time on a weak request could cost you the opportunity to file a timely judicial review. Thanks for staying with us this far. We appreciate your time and hope you're finding this information valuable. Rise in judicial review success in 2025. Here's why judicial review is making headlines this year. In 2025, immigration lawyers are reporting a sharp rise in successful court challenges. With increased pressure on IRCC to process more files, decision-making has become less careful. That means more errors and more grounds for review. Judges are now overturning decisions due to inconsistencies, missing assessments, and procedural violations. This has made judicial review one of the most powerful tools for applicants facing unjust refusals. Even within IRCC, there's awareness of the issue. Officers are receiving more training and internal quality checks are being implemented, but the system still isn't perfect. Court oversight remains critical. Procedural fairness, the most powerful argument. The strongest legal argument in judicial review is often procedural fairness. If an officer questions your proof of funds, identity, or intentions, they must give you a chance to respond. That's the law. If they don't, the court will likely find their refusal invalid. This is especially common in cases where applicants submit financial documents that officers misinterpret or ignore without asking for clarification. When fairness is denied, the court steps in. Why this matters more in 2025. Canada's new immigration intake caps, introduced in April 2025, have made applications more competitive. Officers are under pressure, and mistakes are more frequent. At the same time, political scrutiny around immigration is growing. As public sentiment shifts, more refusals are being issued, sometimes hastily. Understanding your legal recourse has never been more important. Legal help is essential. Judicial review is serious litigation. This isn't a DIY process. Hire a licensed immigration lawyer with judicial review experience. They'll guide you through filing, represent you in court, and help build a case that stands up under legal scrutiny. A good lawyer can make the difference between a lost opportunity and a reopened pathway to Canada. The call for reform. Experts are calling for an internal appeal system for temporary visa refusals, mirroring what exists for permanent residency. They also want clearer refusal letters and a consistent framework for reconsideration. Until that happens, applicants must rely on the tools available. Judicial review and reconsideration. They aren't perfect, but they're powerful when used wisely. Know your rights. Use them wisely. If your immigration application was refused, don't give up. Understand the reason. Evaluate your options and act within your legal timelines. Whether it's a reconsideration request or judicial review, you have a right to challenge unfair decisions and win. So whether this is your first refusal or you're unsure of what to do next, understanding the difference between these two options could be the key to your future in Canada. With judicial review wins on the rise this year, you're not out of options. You're one right decision away from reclaiming your chance. If this video helped, hit that like button, leave your questions or experiences in the comments, and share it with someone who needs this information. And of course, subscribe to Canada Chronicles and turn on the notification bell so you never miss a crucial update that could shape your immigration journey. Thanks for watching, and we'll see you in the next video.